party to call that party and treat that party as a hostile witness. Now, the strategy that we had adopted was basically to serve a subpoena on her, because as you recall, she had decided that she was not going to give testimony even after filing a witness statement. And we decided that we were going to call her by compelling her through a subpoena that would have been issued through the court system and served on her. But today, the Supreme Court gave a decision in which it basically said that Mrs. Jane Adukoya-Mensah will not be compelled, to testify. In our view, the court was wrong. In our view, the reasons of the court were based upon wrong legal premises. But the Supreme Court is the final decision maker when it comes to the law. And we have no reason not. We are bound by what it has said, this morning. We cannot depart, from it. But lead counsel for the petitioner has indicated that he is filing an application for review with respect to the earlier decision rendered on the 11th of February relating to their decision with respect to the compellability of the witness testimony of the Electoral Commission. Now, ladies and gentlemen of the press, the Supreme Court asked itself a question which we deem was a wrong question and answered that question. It said, why does the chairperson need to account to the people of Ghana when she's not a party to the suit? Now, you recall that counsel made it very clear that one of the reasons why we are in court is because of the unconstitutional conduct of Mrs. Jane Adukoya-Mensah as the returning officer under the Constitution. And it is not true that there is only one issue that needs to be determined in this matter. I am surprised that the Supreme Court itself, having set down 5 key issues to be determined, is now reducing the issues to one, which is whether and the extent to which the evidence that we have led shows that no one got more than 50% of the votes in accordance with Article 63 of the Constitution. But we have made abundantly clear in the petition that there were a number of infractions. We are contesting even the constitutionality of the declaration that was made. We are saying that she violated Article 23 of the Constitution because she is an administrative body. We have also said her exercise of discretion was contrary to Article 296 of the Constitution. These are all germane issues under the Constitution and laws of Ghana. And to reduce the petition into a single issue petition is rather unfortunate and smacks of a predetermined agenda to rule against the petitioner in this matter. The Supreme Court was called upon this morning to exercise discretionary power, judicial discretionary power with respect to whether we should reopen our case. Now, in doing so, the court was bound by the provisions of Article 296 of the Constitution, and we think that the reasons, as I've said, that the court gave are not acceptable. They are not tenable. The reason is simply because you cannot expect that we should have made our evidence, the evidence that we're going to present to the court, available ex ante or before the fact, so that the court will now determine whether or not this is evidence that will help the case. In any case, the petition and other pleadings filed before the court makes it clear, and any trained lawyer will know that the pleadings show very clearly the evidence that would be led in order to be able, to prove the facts in issue. And so for the court to say that we were bound by law to make our evidence available for it to assess before allowing us to reopen our case is a legally problematic proposition. And therefore we disagree with the court. We think that the court, by this decision, has not done the people of this country a great service, in the sense that Ghanaians are interested in knowing the truth. Our constitution is very clear that justice emanates from the people and must be exercised in the name of and for the welfare of the people. The justices today have not given us a reason to believe that they want the people of this country to know the truth about what happened, that they want the people of this country to be able to say why figures kept changing on the from the 9th of December till date. If you go to the website of the Electoral Commission, the figures have changed 5 times. Are we not worried as a nation that the returning officer appointed under the Constitution cannot even explain to us what happened? She made a declaration based upon a figure that she herself changed without recourse to the law. Is this something that we want public officers to be, engaging in? And secondly, she's a public officer. And as a public officer, she's accountable to the public. She's paid with taxpayers' money. Why is it that she cannot be called to testify? Why is she being treated as if she's a private person? Why is she being treated as, why does the court treat this important constitutional matter under Article 64 of the Constitution, something that could have been brought by an ordinary citizen of this country, as if it is a mere private matter, as if we are involved, as I said a few days ago, with a debt collection matter? This is not a debt collection matter. This is not a commercial litigation that we are engaging. And so we are highly disappointed with the decision of the court. Maybe the issues that we have raised today will feature in the review application that we have brought before the court.
The motion for stay.
And we are also filing a motion for stay of proceedings pending the hearing of our review application. So thank you very much. If you have any questions.
Doc, at the risk of social media abuse, I have to ask, how much further, how much longer is your side going to go? For a number of applications now dismissed, the substance of the case itself, we haven't had a pronouncement on that yet, and so we cannot seek to say what would come out of it. But at these very press conferences, sometimes the comments that we get from your side suggest that you don't even believe in the ability of the court to determine or give an impartial judgment. I would reference a comment you just made that suggested that the ruling we had today was predetermined. How much further are you going to go?
Well, thank you very much. We are determined to go as far as the law allows us to go. And that is because we want the people of this country, the discerning citizens of this country, to see everything play out in the court, and that is the highest court of the land, and for us to be able to let everyone see that our resolve to pursue the truth is unrelenting. So we'll go to all the lengths allowed by law. As we have said, the Supreme Court has a review jurisdiction, and we are invoking that jurisdiction to take a second look at its own decision. And the review application will be filed with very solid legal arguments that we think should convince the court. If the court is not convinced, whatever options are left, we will pursue them. But we are doing this for the people of this country. His Excellency John Dramani Mahama brought this petition for the defense of the Constitution. He has a community of interest with the Constitution. And I want to make one thing abundantly clear. If you were the plaintiff in this matter, if you had sat in the comfort of your room and tallied all the figures, and if you were convinced that this matter, the declaration was in error, the Constitution allows you to bring an action. And your community of interest is with the Constitution, to defend the Constitution of this country. The judges have sworn an oath to defend the Constitution of this country. And so every constitutional issue that we think is germane and legitimate towards the resolution of this matter, we will raise until final judgment is given.
All right. Look, thank you very much. I stand corrected, but at the very heart of this petition is the fact that the petitioner claims that no candidate attained 50% plus of the total votes, valid votes, thank you. And the petitioner has come to court again, also asking the court to annul the results as were declared on the 9th.
Okay, yes, on the declaration.
On the declaration,
yes.
Okay. Now, my question is, so far, has the petitioner been able to prove that none of the candidates actually got more than 50%? If no, is it going to be through the cross-examination of the first respondents that will reveal that none of them had more than 50%? If no, then your case is dead now, is it?
Well, don't prejudge the case. At the risk of being held for contempt, I would dare say that the case we have brought is very clear on the face of the petition. If you read the petition, it is very clear why we have brought this matter. Now, in respect of the figures, we made it abundantly clear from the beginning that these were figures compiled by and announced by the Electoral Commission. You remember that we wanted to inspect documents. Our request was not granted. You remember that we wanted her to answer interrogatories, which are allowed under Order 22 of the High Court Civil Procedure Rules. At first they said they were not applying CI 47, and subsequently they had to rely on CI 47 to save themselves. All right. They did not permit us to. They did not permit us to administer the interrogatories. These are all mechanisms but allowed by law to elicit evidence. And I don't see why the petitioner in this case, or anybody filing a petition as a citizen of Ghana in this case, cannot obtain information from the person who conducted the election for purposes of proving that the declaration she made was unconstitutional because none of the candidates obtained more than 50% of the votes. And let me say this, you see, there is a tendency, and I think that is where we have all gotten it wrong. Okay? I gave the example of Sixtus, you know, as an ordinary citizen mounting this challenge. Could the court have asked Sixtus to go to all the 275 constituencies and bring pink sheets? But read Article 64, Clause 1 of the Constitution. It says any citizen of Ghana may bring an action. So you can rely on the evidence compiled by and announced by the chairperson. In fact, in any jurisdiction, having seen situations of multiple summary sheets coming from regions, having seen situations of pardon, vote pardon, and admission of vote pardon by the respondents themselves, the court itself would have ordered an inquiry into the extent of vote pardon. And that would have not been based on our figures, it would have been based on the figures compiled by the Electoral Commission. And by the way, no party goes into an election produces figures. The official figures are produced and announced by the Electoral Commission of the Republic of Ghana. Why is the commission not throwing that evidence to all of us to say, look, here it is, this is what we did, now tell us why we were wrong? Why are they not doing that? And why is it that you as journalists are not asking that question of the Electoral Commission? You know, the notion that just because the principle of law is that, he who alleges must prove. Then it means that because the petitioner has come to court, he must produce the evidence by himself. Cross-examination is one way by which you can prove that burden. Why are they running away from cross-examination? Why are they running away from bringing evidence? And by the way, we filed a notice to admit facts. Okay? The law is that after 14 days, if you don't answer, if you don't admit, those facts are deemed in law to have been admitted. All right? So, in fairness to the petitioner, the facts enumerated, for admission are deemed admitted. And let me say this. You see, they have decided they are not giving testimony. What is the legal consequence of that? It means that our petition and the evidence laid in proof of the petition stand unrebutted. That is the position of the law. And let anyone come and challenge me that that is not the position of the law. The court should have actually gone ahead to strike out their figures, their witness statements and their pleadings. Why is the court not doing that? That is a legitimate question that the petitioner is entitled to ask.
Just a quick one on the quest for Madame Jean Mensah to be cross-examined, testify and be cross-examined. The court in today's ruling said that you had not proved the relevance of testimony. Doc, you are shaking your head. Indulge me when maybe. You had not proved the relevance of her testimony to your case. It's one of the many things that was said in the ruling. I don't have the benefit of a written text. I just had to listen to it.
Yes.
And you have demonstrated, again, at a lot of these encounters, that there's a critical part of this case that is hinged on Madame Jean Mensah's testimony and her cross-examination. And it seemed that is where we are now. She must enter the box at all costs, putting it, in a layman's terms. Let's assume Jean Mensah falls sick or takes ill tomorrow and cannot. What will be the direction of your case?
The court will adjourn until she's well enough to testify. that is said on a lighter note. But Sixtus, I think you may be going down the route of saying that, look, we haven't produced sufficient evidence to be able to discharge our burden. We think we have. All right? And again, the legal consequence of not testifying will have to kick in. All right? At this point in time. And I think that it is important that we highlight the fact that they have decided they are running away from giving evidence. And as journalists, I think you should be asking them more critical, questions than you are asking the petitioner. At the risk of being, petty, I think you are being unfair to the petitioner. You journalists are being unfair to the petitioner. You are not asking them critical questions. You file a witness statement. You represent it to the entire world that you are coming to give evidence. Why run away?
Maybe.
And by the way, before you come in, let me say this. Before you come in, you have, you saw the video in which Mr. McMenu said that they could also prove that there was pardon in favor of John Mahama, right? Is the court not interested in that? McMenu basically admitted that there was wrongdoing by the Electoral Commission, but the wrongdoing affected both parties. Is the court not interested in that? So that Jean Mensah could come and then say why she parted votes in favor of the petitioner and parted some in favor of the respondent. And then also let us see the extent to which the vote party helped one party or the other. Isn't that an important question that needs to be answered? And who best to answer the question than the person who declared the results?
Let me ask. Doc, just a quick follow-up. You made a point about the fact that as it stands, your evidence has not been rebutted. Should that not be good news for you and allow for the case to proceed for judgment to be delivered? And the second point, Doc, at the start of proceedings, we cited a letter that had been written asking for some additional arguments to be made. The court said it has noted that. Do you think that if you had the opportunity to perhaps address the court on that, it could have changed how things went? Then I realized that a larger chunk of your address this afternoon.
Now, Akable, you tend to ask double-barrel questions. Can I take them one after the other? All right. So, in the first, place, you are asking
about the evidence that you said has not been rebutted. So the question is, if it's not been rebutted, that should be good news for you. You should apply for them to strike out.
If we were interested in just legal technicalities, the court, is applying legal technicalities at this point in time. We are not interested in just the legal technicalities. We are also in pursuit of the truth. That is why we think it is important that she should testify. All right. In addition to what we have, the evidence we've laid, we think that if she testifies, Ghanaians will see that we didn't just come to this court making vain allegations without proof. We have laid evidence, sufficient evidence to show that there was vote padding, sufficient evidence to show that there were, conflicting figures from, regions and constituencies and so on and so forth. All right. So we also made, it came out very clearly that the Form 13 that she said was a Form 13 wasn't a Form 13. Okay. And as I promised you yesterday that there will be very, salacious evidence coming out with respect to Form 13. And I told you that Form 13 is the reason why they are running away.
And Doc, is this evidence that was not available before you filed your case such that you could have put it through your own witnesses?
No. Okay, so, Form 13 was available to us. All right? But Form 13 wasn't put in our, we didn't put Form 13 in. Form 13 was put in the witness statement of the electoral, of the first respondent. Now, Akable, you do remember that there was an attempt to put that form into the evidence through Dr. Michael Pesa-White, and we resisted it. And then it was Justice Gertrude Tokunu who still pressed, and the form was shown to Pesa-White. And you heard what Pesa-White said. When he said it, the court went very quiet. All right? He said, this is not the Form 13. That the Form 13 as spelled out in CI 127 is different from this one. Was counsel, my good friend Mr. Justin Amenivo, not in court? Why didn't he protest? And why didn't he, get up to show to the court that the Form 13 they had presented was the same as the Form 13 in 127?
Doc, finally, I was asking about the letter and the fact that you were
the court, we thought that, if we cited those authorities, it will assist the court, okay, because it's a court of law and a court of justice. And therefore, the issue, you remember that the issue was raised very late at the proceedings yesterday, when Justice Mafusa basically said that there was a judicial bar, because Jean Mensah was not, she was a party to the proceedings. And we said, no, she's distinguishable from the Electoral Commission. All right. There was no time for us to be able to address the court sufficiently on the matter. But upon further research, we decided that we were going to cite these authorities to the court to assist the court in coming to a tenable legal conclusion. Unfortunately, the court took the letter, but decided to treat it with contempt.
So Doc, is it your contention that if the Supreme Court goes ahead based on the evidence that the petitioner has put forward to determine this matter without hearing from the respondents, it will be a miscarriage of justice?
No, can you ask the question again?
No, I'm asking that, are you saying from your arguments that if the Supreme Court goes ahead to determine this case, this petition that is before it, without hearing from the respondents, it will amount to miscarriage of justice?
Well, not necessarily, but justice demands that the truth be told. And that is why we are in pursuit of the truth.
All sides are
Okay.
Doc, you indicated that the truth demands that justice be told. In this
Justice be done.
Justice be done. In this case, it looks like justice for you is for the EC chair and the returning officer to answer some questions. It's so clear that it's not going to happen. There are people within your party.
Are you know the outcome
so
of
far,
our review application?
So far, it's clear.
No, you know the outcome of the review application. Are you predicting?
So far, it's clear it's not going to happen.
I mean, you see,
and with your comment that you believe that some of these rulings have been predetermined, people within your party are asking you to withdraw this particular case. There are a number of people within your party who say, look, this thing will not end us anywhere. Just withdraw it. Would you do that?
You see, when it gets to a point in time that ordinary citizens, lay people, can predict court rulings, all right, I leave the justice or fairness of otherwise of the rulings to your judgment.
I think this should be the final question. Sam is very scotchy.
Okay. And you back court no, see court no, akoye arehusem kakra. It's say Jane Mensa oye electoral commission ni dream train ya abatra tu yi na gina ne so no. Ye ba ne se enka court man ho kwan. Nanko omegina dakanu na nsem bebre amanfo bisa no watimi ya no ankoba ne sa court say oni ye nyadwen nti nanso biom akwakoye 70 a me no kasei omo sei wo mo ma ho kwan majemensa emma adakanu na ne awo ho sem ne say ye mra ye adwuma ogana ha no eye evidence act no section 72 ma ho kwan se obi a woni nokura nyaadwe nokura wutumi fe no obeda no wadanse enne yamra no mom eda nchen enne yakofa abrochire mu abibira be hihye mu a yedi aka asem enne ne hunya pass obi abehu ni se yen as petitioners no ya dwum point na ne se ye bedi nokura na chia kosisi ensa beka nokura no ensa se ye pe nokura hunu a nukrani na se jemensa eba begina de kanum na ne esi yankasa no waka esense sa wodwa nsem no bia ka ya for example you say ye di abanu bi keka ho vote pardon eya makmenu a kasama na ekufuado wabegya atum se ayampa ye di abanu bi keka ho why na di abanu keka ho jemensa nkwa ne betime yi ano se wiye no ntifi wa jemensa nkasa ba be ka kire ense why mistakes bebre e wonu na asemu na denti na why mistakes na anabe gina de kanum na kire from 30 a we use form why di e ka asem na ngata no why use form a what ye di use anya no nso na we use ye uko use form for enti ye na me no kase ye were results baku enum a ye nim results ko ai di edum Ghana enti se sana tie na nia ogina mu oyaba no yesi bra begina betma na wo say unma why na betima bekire mu why na betima abekire nsem na esie no we na esie why na betima kire mu na wa kakra say Supreme Court baby Supreme Court dinano nanka I say Supreme Court ka say me na say accountability ni yemfa evidence maye ade omo amaji atum say mistakes adia magmenu angasa say dia ade no bi keka ho enti ade intina o transient by evidence bembi na baba kire say ye dia ade no bi aka ho evidence be na kire say ye di den yamfa ne say go bi fufu bi kura na nya jo mahama no petition a angasa na baka jo nkonko fa na results mra na ye results ye de ba court no eye nia o man no mra ama no ho kwan so on fa results mra ono ne jimensa wa bana se problem we wa ono kwa ni results na wo so ba be kiretim onu ni agina so se omra no nkyerɛ mu baako ɛyɛ dɛn ɛna mistakes yɛhu na yɛhu yɛ pepɛ sɛ mekyɛ mo bɔ sɛ yɛn as petitioners no deɛ yɛbɛdi akyirɛ obi bisa sɛ ade nti na yɛn withdraw ne yɛn nkɔtɔ dabi yɛama sɛ yɛbɛsi ɛwi no nkoa o yɛbae nso sɛ ghanafoɔ nyinaa bɛhu no korɛ wɔ asɛm mu ɛsiane sɛ John Mahama ɔde no ho abɔ afɔdeɛ sɛ obi bɛhu no korɛ wɔ asɛm mu na wo a wote fie a wotie mi no wɔhu no sɛ abatoɔ no yɛtoo no nokorɛ nie ɛba ne sei mistake ba ha ɛna mistake amba ha ɛba ne saa na nea yɛbaa court no ne yɛsaka yɛba court na nokorɛ no kora pii a ɛno a ne adeɛ yɛpɛ nokorɛ ɛnti ne yɛwɔ ha yɛda mo ase
But if there are more questions and people want to ask questions, they should have a right to ask the questions. We can't stop them from asking their questions. Colleagues, good afternoon. We want to start by reacting to a number of comments that have been made by the spokespersons for the petitioners' legal team, and then we will deal with our summary of what has happened. I'm sure you have all followed, and so we don't need to even spend so much time on that one. Our colleagues who speak for the petitioner started off by telling you this afternoon that they are of the view that the Supreme Court of the Republic of Ghana is wrong in law, at the ruling that it has delivered this morning. They also claim that the Supreme Court has reduced the petition to a single issue petition, and that smacks of a predetermined agenda. I'm sure you heard the words used by Dr. Ayine, that the Supreme Court has reduced the petition to a single issue petition, and that smacks of a predetermined agenda, ostensibly not to rule in favor of the petitioner. Now, we want to deal with those first two. While dealing with a third matter, they keep bandying this word about truth. What is the truth? And that the truth must be allowed to come out. We'll deal with the question of truth as they talk about it. And then this claim that the Supreme Court is shielding the EC chair from getting into the box. In fact, in Chi, they make the argument that the Supreme Court doesn't want to allow the EC chair to give testimony. We'll deal with all of those before we come to our submissions. And then they make the argument that they are doing this for the people of Ghana and in the defense of the Constitution. We honestly don't think that is true. We'll deal with that one. First, let's deal with the issue of the court being wrong in law. This is the Supreme Court of the Republic of Ghana, a bench of 7 justices. And I think on about 2 occasions, 2 others have come to join them to review some of the applications before them. Except for the application for leave to amend the original petition, it is true that all the applications that have come before this court have fallen flat. But how can it be that the petitioner's communication team now argues that the 7 justices or the 9 justices are always wrong in law, and only Mr. Chachuchikata is the one who understands the law, knows the law, and is therefore always right? It cannot be. The last time they won some arguments that some of their paragraphs of Mr. Rojo Metununu's witness statement should not be struck out, you heard them right before you that it was a monumental victory. Are those not the words that they used? And we keep making the point that it is not fair to the judicial system, it's not fair to our democracy, it's not fair to the people of Ghana that when you lose an application because it is not grounded in law or because you have failed to meet the legal standards, then you come here and literally poison the minds of the public and make claims that they may be having a predetermined agenda. That's scandalous of the courts. It's scandalous of the courts. When you make a legal argument and it is upheld, that one is good. When you make an argument and it doesn't meet the threshold, then it means that they are wrong in law or that they have a predetermined agenda. The Supreme Court has not reduced the petition to a single issue. We tried our best to transcribe the ruling. We are waiting for the written version of it. The court said that the major issue, it didn't say there was a single issue before it. It said the major issue. And time again, colleagues, we have read out to you the 5 issues that the court is seeking to determine. And the court says that the major one, and I believe in the minds of every well-meaning Ghanaian who has been following, and I indeed heard it from your questions, the major issue, you forget what they said earlier that they had won. The major issue they brought to court was that nobody had crossed the 50% threshold. And everybody's been looking forward to them adducing evidence to prove this. They have been trying in the last 1.5 weeks to shift it to a new constitutional accountability argument. And the court reminded us the last time that you came here under Article 64(1). The court today has said that the major issue, why do you then decide to mislead the public that the court has reduced the petition to a single issue petition? I think it is very unfortunate, and we must start off by correcting some of these issues. Now, they talk about the truth, and that the truth must come out. The truth must come out. What is the truth? The truth is what the EC chair has declared as at now, that Nana Addo Dankwa Akufo-Addo validly elected because he got more than 50% of valid votes cast. The truth is what is backed by the results of the 38,000 polling stations, or the 275 constituencies, or the 16 regions, which anytime we give them a calculator to calculate, they get 47% for Mr. John Dramani Mahama, 51.2% for Nana Addo Dankwa Akufo-Addo. That is the truth. If you come to court claiming that there is another truth, you have to lay it before the court. So where is the truth that you say you want to lay before the court? You remember when the court asked them, they said they had left their truth at home. They did not bring their truth to court. So which truth is the court supposed to look at? The presumption of regularity is before the court, and you say there's another truth. Where is it? And you say you won't bring it. And that the EC chair must be compelled to get into the box so that you can conduct some surgery and explore the truth out of her. We are not being fair to the people of Ghana if we continue to change the goalpost at every hearing. Now, they continue to make this argument that the Supreme Court is shielding the EC chair or preventing her from getting into the box. The court has said over and over again, and we hope that our colleagues on the other side will pay attention to what the court is saying. The court has said that you cannot compel her to get into the box. She will elect. Indeed, your own argument earlier was that she had elected to get into the box. And the court, after listening to the argument, showed that no election had taken place. So that argument falls flat on its face. Why do you now come and tell the people of Ghana that the Supreme Court is shielding her and preventing her from getting into the box? Because she is somebody or a party who you have brought to court. And the rules settled from the beginning that you cannot compel her. Whether you come by subpoena or you come by any other instrument, you cannot compel her. This argument, therefore, that the Supreme Court is shielding her is one that, again, our colleagues in the media, I think you have to be very quick to call out and let the public know is not true. That is not what has happened. They are the ones who objected to the closure of the case of the first respondent without putting her in the box. They objected. Why? Because they said she owes constitutional accountability. And the court has said that you haven't provided any authority or any law to show us that she should be treated with a different set of rules. Why do you misinterpret that to the public, that the court is shielding her? We think that these things should be called out. Now, there are 2 paragraphs in the affidavits that were before the court today that I want to read out to you. And I beg you to pay attention to this. This is the affidavit of Mr. John Dramani Mahama in support of the motion to reopen his case. Remember, we kept saying to you in the beginning that it was becoming obvious that they have not succeeded in making any case before the court. And that what they have put together before the court, 30 out of 35 paragraphs, are complaints about the declaration. It doesn't attack the validity of the election or the validity of the results whatsoever. And they said what we were saying was not correct. And we said, bring your witnesses to come and prove it. 3 witnesses they brought could not prove it. And when the Supreme Court heard them announce that they have closed their case, and the first respondent said, I will not get into the box to adduce any further evidence, determine this matter on the evidence that they have brought before you. And we said same. They objected and said they wanted to bring her in. The court ruled on the 11th of February, the law does not support that position. Then they have come with an application to reopen their case. Now listen to paragraph 20 of that application and that affidavit supporting the application. It says that this witness has a unique role under the Constitution in respect of the presidential election that took place in Ghana on the 7th of December 2020. And having her testify is critical to this court. What Mr. Mahama and his lawyers are telling the court that they themselves don't believe that they have made a case before this court, and that if this EC chair is not compelled to get into the box, their case is collapsing. That is what they are admitting by paragraph 20 of their own affidavit, Mr. Mohammed's application, Mr. Mohammed's affidavit to support the application that they made. That if this witness does not get into the box, or if this person, this party, is not compelled, dragged into the box to testify for them, they have not succeeded. But if you've made a case, why are you begging the court, going up and down, misleading the public that if this person is not brought into the court, you cannot make a case? I thought they said initially they had won, or that nobody won, and that they had 5 witnesses who are going to prove it. They are now telling the court that if the court does not compel Jean Mensah to give evidence on their behalf, and yesterday you heard that they want to call her as their witness and they will treat her as an adverse witness. And by the way, the court explained today that that argument is not sustainable in law. It falls flat on its face. There's no legal position to back it. They are now saying that if she is not compelled, they can't make a case. Now, when yesterday the learned Akoto Ampao in paragraph 12 of the affidavit supporting our position said that the instant application does not raise any new matter of relevance which could not have been discovered by diligent effort and does not warrant the grant of leave to petitioner to reopen his case. They said this was irrelevant. And today you heard the court essentially going back to these arguments and the authorities that we had raised to come to a ruling that the position of the law is settled, that you cannot compel a party to get into the box to testify. So it is not about truth, some truth which you say you have left at home, and you are asking the court to drag the EC chair into the box so that you can conduct some surgery on her and find the truth out of her. It is about a legal argument of whether or not she can be compelled into the box to give evidence. And indeed, if you have some truth, why don't you lay it before the court? Now, colleagues, we heard you argue that, or we heard you question that now some of their own supporters are saying that perhaps they should withdraw at this point. And indeed, it is our view that Dr. Ines skirted around the issue, didn't respond to the question. Says he leaves it to the judgment or the conscience of people. Why are NDC supporters now saying they should withdraw? Because they are observing before their very eyes, as this thing is televised live on TV, that their petitioner and their lawyers are not making a convincing case before the court. What they told them is not true. And that is why now they are asking the court to reopen their case so that they can put a party on the other side in the box and compel her to testify to make their case. It's becoming clear right before your very eyes that this is the reason for which their own supporters are telling them that it is about time that they abandon their case. But we want to conclude by dealing with this argument they make that they are doing this for the people of Ghana and they are doing this in defense of the Constitution. We vehemently disagree. What they are doing, this so-called petition before the court, is not for the people of Ghana or in defense of the Constitution. It is for the political interest of Mr. John Dramani Mahama, who desires this media spectacle to sustain his brand equity and run again unopposed in the NDC in 2024. Let's be honest about it. It's not in defense of any constitution, because if it was, the Constitution says that our legal system is adversarial and therefore you can't compel a party in the box. Why would you be claiming you are defending the Constitution and asking the Supreme Court to turn the Constitution upside down? Those arguments don't hold the test of time. Today, the court has reaffirmed the decision it made on the 11th of February, that you cannot masquerade the same application in a different dress and expect it to do that which the law does not allow it to do. We'll take your questions.
Right. Honorable, good afternoon.
Good afternoon.
So, on several occasions, whilst addressing us, you have referred to the fact that the petitioner also appears to be panning towards public opinion and saying things out of court just to win public sympathy. Unless the second respondent doesn't believe that public opinion is important, I'd like to find out from you. First of all, there was an application for interrogatories. It was dismissed. In the public opinion, it was the fact that the EC, the second respondent, the first respondent, I beg your pardon, has something to hide. Then there was another application to allow the petitioner to inspect some documents. Again, your counsel opposed to that. What went out in the public domain was that there was something to hide, and that is why you were opposed to it. Now there's a refusal to present witnesses.
A refusal to compel.
Well, first of all, your side said you chose not to present the witnesses. Again, the opinion out there is that then it means there is something to hide. If there is nothing to hide, and if the public opinion is also that important, why don't you just open up?
Well, we have said over and over again that this is a court of law, not the court of public opinion. What our colleagues on the other side do is that they come to court and they make arguments that, according to the Supreme Court, these are not my words, according to the Supreme Court, are not backed by law. The Supreme Court has said on about 3 occasions that we don't know any law that supports what you are telling us. In fact, 2 days ago, they asked that this application you have brought, what's the legal basis? So we are praying to the inherent jurisdiction of the Supreme Court. There are times when they cite cases, Ellis Tamaklo, the court says it doesn't apply. Several times they end up speaking at length, and the court says that the law doesn't support the grammar you are speaking. These are not my words. It's the position of the court. Then they come here and they spin the story to create a different public opinion, that the interrogatories are not being up. And you heard Dr. Ayine repeatedly say that the interrogatories were not allowed because the court claimed that CI 47 doesn't apply. We challenge him. The court never said that. Get a copy of the certified ruling and read it. The court has never said CI 47 doesn't apply. The Supreme Court holds all the powers of the courts beneath up to the Supreme Court and has been using CI 47. CI 99 applies to the procedure in here, but some of the basic powers in CI 47 or as amended 87, etc., they all apply. And the Supreme Court, in using CI 47, said to allow interrogatories, they must be relevant. The question is a question of relevancy. If you come and you ask irrelevant questions painted as interrogatories, the court will not say that just because interrogatories are allowed, it should grant you those when the questions hidden in that box are irrelevant. And you heard His Lordship the Chief Justice said that this your application falls flat on the grounds of relevancy. So if you come and you poison the public mind that they didn't allow it because they have something to hide, you are not talking law, you are talking propaganda. If you come and you say if they have nothing to hide, why are they not allowing us to inspect the documents? You are not talking law, you are talking propaganda. Because to be granted leave to inspect, you must meet a certain legal... But why don't you want to meet the legal standards? Why don't you want to make a convincing legal argument? Do research, back it with authorities. You heard us yesterday, quote authority of authority, Poku versus Poku, Berema, all of these ones quoted. Today you heard the court even adducing some of those to back it. You don't want to come with arguments and legal basis and with propaganda arguments to the public. Why do you want to tell the public that somebody can be compelled? When indeed that's not the position of the law. These are not my words. This is what the Supreme Court is saying. So the court of public opinion matters. But you, our colleagues in the media, we won't fight with you. We won't say you are not being fair to us or argue with you like that. In fact, we apologize on their behalf to you for what they did. But you have a responsibility to help educate the Ghanaian public that what the people are saying is not law, it's grammar and propaganda. Because there are legal standards that must be met. And the court has been, in fact, today, let me just go on one small tangent. If you notice, the court for the first time set out the parameters for determining when you can grant leave to reopen case at the Supreme Court. Any impact on results, obtainable by due diligence, the materiality question, importance of integrity of the process, prejudice, miscarriage of justice. They have laid down about 4 or 5 principles today before you and I this afternoon. This is law. not grammar. So when courts below are now looking at this matter, this is what they will apply to. We pray you to also take an opportunity to help us educate the public so that people don't go telling them stories. Because if that was the case, we have hinted you twice or thrice that, listen, if an argument can be made for a party to be compelled, i.e. the EC can be compelled, then it means that John Mahama can be compelled. Not so. So we should stop the legal work and now make an argument that, okay, we are come to compel John Mahama, we are come to compel John Mahama. We provoke thinking by throwing some of these things out. But just to answer your question, the Court of Public Opinion matters, but you have to help us to educate the public so that people don't throw propaganda out there. Yes, sir.
What does it hurt, whether in law or in the Court of Public Opinion, if the returning officer for the December 2020 presidential election, Madam Jean Mensah, takes the stand? Again, we still are not clear what direction the court is going to go on Thursday. So question is whether you are still going ahead to file your addresses or you are waiting on the new processes that we have just been notified of to see how that goes.
Sixtus, I'll deal with the second one first and I'll come to the first question. So you heard at the end of the proceedings today, Mr. Chikata announced that they will be applying for 2 reviews. The review of the February 11 decision and the review of this decision as delivered. And that they have filed, initially that's what he said, they have filed in the last, he said in the last 20 minutes or half hour. And the bench asked, have you filed or you are filing? And then later he changed, he said, we are in the process of filing. I believe it should have been filed by now. Indeed, for those of you who are in court, when the bench sat and started reading out the decision of the court, then one of their lawyers with the documents got out, even before the ruling was completed. You saw it in court. And you can tell your viewers and listeners whether what I'm saying is true or not. Stepped out to go and start filing the process.
We saw somebody walk out of the court. We don't know where the person
He's the one who went to file it. It's a matter of public record. But here's the point. The exchanges between the bench and the bar was to the effect that, so what happens to the submission of addresses on Thursday? And His Lordship, the Chief Justice, says that our orders still stand. So those orders we understand that we should respect. And he said that if the court is seized with it and the registrar has given a date for it to be heard before then, this court will come back and hear it. And we'll be here also to make our views known on that. Your first question was about what does it hurt? It turns the Constitution of Ghana upside down. It turns the adversarial system of law, which is in our Constitution, upside down. It compromises the time-tested, laid down procedure for adjudication in our courts, which is that when you allege, you prove. That when you tell the court that you have closed your case, you must have some extraordinary circumstances to demonstrate to the court before it will grant leave for it to be reopened. When you don't do that, you don't come, excuse my point, with the propaganda argument of, oh, but what does it hurt? It hurts the Constitution, it hurts the law, it hurts justice. We are here for justice. We are here defending every single vote that the 13 million people cast. Those who voted for Nana Akufo-Addo and those who voted against Nana Akufo-Addo. We are defending all of those votes. If you say that those numbers are not correct, why don't you want to take the responsibility to come to the court and say, these are the numbers that show that this one is not correct? And you say that it is critical to compel Jean Mensah to get into the box so that you can make him the case, or you can make your case. In 2013, Dr. Afarijan entered the box, not because he was compelled by subpoena. Dr. Afarijan entered the box because the brilliance of Alhaji Dr. Mahmoud Baumia in demonstrating 11,000 pink sheets and the problems with it compelled Dr. Afarijan that if he did not get into the box, the job that he had done was going to be set aside. There's a major difference between these two cases.
So you're giving us a duty to go and educate the public that this is a court of law and not, for grammar. Now, the ruling of the court today would mean to say somebody who just voted, a first-time voter, that the chairperson has, answered questions on behalf of the commission. And
I'm sorry, I can't hear you. Well, you're saying that the ruling of the court today is
yes, that... It suggests to say that once Madam Jean Mensah answered in the response, then it means that the commission has answered. So the understanding they are going to get is that Jean Mensah is the Electoral Commission.
Go ahead, I'm listening.
And so in that case, how then do I go and convince somebody who just voted for the first time that this is the court is not shielding the chairperson of the Electoral Commission, but rather is making sure that the vote they cast is protected.
Because somebody came to court with an application that the numbers or the declaration that I hereby declare that Nana Danko Akufo-Addo was validly elected and is therefore president-elect. Somebody came to court saying that declaration is not correct. That person is refusing to give evidence to prove it. He's brought 3 witnesses, and now he's saying that his witnesses didn't do a good enough job. And until they drag the EC box into the chair, he can't make his case. And the court is saying that that flies against the constitution, it flies against the adversarial system, it flies against the system of law we practice in this country. It has nothing to do about or to do with the EC chair answering questions. If you want the EC chair to answer questions, we can invite her to Parliament. There's a whole constitutional provision for parliamentary inquiry. But the forum that you have chosen and the constitutional provision you have invoked, Article 64(1), is not the platform for general constitutional accountability. Are there any questions, my colleagues? Thank you very much.
Abusanfo ni adehia enemwo ha yebeda mo ase enenso eyeda etoso edunsia yehia ewo ha na ansa na no metre sene da ya no mo ye adwuma no efe adwuma ansantrofo mo ye no eye enti mi nso magina afidie so na mapa mwacho ye nuanum NDC fo omo nsam en omo kasa tietia mo ne ntoko omo ne mo ko mo bisa asema na akwese abufuo na nsam omo kana kwa kasa twitwe ne mesre ye no ma na ye adwuma yi enti no mamo mfa eye hwansena ho ahi na mo kwabre mu kuro ya pa chawa ma yenuanum NDC fo mo kasa na munye hwam na munye kra na yesai atwa so biema ene asema ye ba wo hase no ehu behia opani Dr. Ayene Mr. Kasa eno be kasa ye e kam yakwa se ye ka ni egu eye Supreme Court mpanifo hu fi no enye ehu hia ye pa sanse wode wasem eba Supreme Court a gidi a wo nyina ne se ahwene ti won pani anim a ebi nyira edisa wode wasem ba pani anim pani ni ka asem na asa ba abonten na wode kasa twitwe kasa emunye de kasa huntie na wode ba na wo kasa nokura Ghana fo peso mu hunu eye mpanifo yi a mo Supreme Court yi epese omo kasa a eye kasa enye kasa ebu court animtia enti Dr. Ayene mesre baby o bia mi se wotia on pacho enye kasa eye kwa na wo sa ka biem se ene Supreme Court nsem o kan ye no so no emma pepepe yo atentenie o masini trase na mra no o mo afa no madu mra ne komu a eye kasa enye papa na biem mo san kasa enye Supreme Court mpanifo yi omu asan ehye eye Madam Jane Mensanchi ena mo kanisie ena ase omu peso be kasa enye kasa efe kra abusu senka ye kan bi panke nei o senka dwumadi a ye di wo Supreme Court onfa na ni breso nanka onfa no se eye asem ehu hia sempo yesi opani Mahama court oba ye Obama Ghana fo enso ye hia court dem a empredunsia emu mienu pe no aba emu du nan no omaye nanso no ono yenka se ana yenka bibia mfentia no asambe na aba abusuafo asama aba ne se Ghana ha ye mra ne kire wa wo bokwa edu no ona ade ho adansidie ba ye Evidence Act section 1417 ekire ana wo konso enya adansidie keke adansidie mu oduo etisa wo court na wo bo nkro wie wo kan wa asem nyina wie na wa wo de to court anim se wo nsem a waka no wani age ho ye pa enti no wa asem no wa bo nkro wie watopunum na court so de nano asem atoso na court nano asem toso wie na anoyifo no nso aye respondent no omo so di omo no asem aba na wei adansifo amofra omo ne nsem a mo kan wo court nyina no na ensisi so na enyina mra so na nya nsem a awose aye anoyifo no omo sai omadaje enu ti ensem a court kan ne se sempo upesa wodi ahoma eso aye maami Jane Mensa kon
na obegina adakam na odi adanse a emra ne nkyerɛ saa yɛni mmara nso a yɛdidi me masɛm ɛne yɛdidi wo wasɛm ana mmara foforɔ nso a yɛdidi maame Jane Mensah asɛm emra ne yɛ baako pɛ na Ghana ha mmara bia ne ho abetimi ahyɛ obi so obegina adakam na odi ho adanse ɛna wakɔ akɔfa dan no ɛpono n'akyi ɛna wo sai aba sɛ wo case a wankasa wo de wano enye obi na kan no wo close wo case na wo se wadi wa agro nyina awie wabɔ nkura awie no wo sa se court makwan na bie wa asɛm no na de kronti a wo bie wa asɛm no ne sɛ wo pɛsɛ court ɛde enhyɛ ɛhyɛ Madam Jane Mensah no begina dakam na toto na no court na asɛm o ka ne sɛ ansa na obebi asɛm ani no na bia okuta dansidi bia dansidi na bra na wudi asɛm no ne yenya nhuyɛ ɛnyɛ no nko a empokra dansidi no na ɛwɔ sɛ wo kyerɛ mu sɛ ɛyampa ɛyade na wo hwehwɛ na woni abre sɛ wo hwɛ saa dansie na wo nsa nka na afei na wo nsa aka ɛnyɛ no nko a ɛwɔ sɛ dansidi ni dansidi mu odu a ebetimi asakyera ɛyɛ asɛm na yɛ di nani dabi we di ensɛm a mo de ba court no ɛnya dansidi fufuro bia na mmom asɛm a mo kan sɛ yɛmi asɛm nani na omuntimi santwe Madam Jane Mensah emba begina ɛyɛ court anim ɛno na court ka sɛ emra no enkyerɛ saa na nya de obetimi ayi nempo ɛno a yɛgyina ha yɛsa kan asɛm baako sɛ Justice Olenu kan asɛm bi sɛ obi bia obɛkɔ court a obegina obi asɛm so sɛ wo de nipa no bɛka na asɛm ansa na wasɛm mu ayedu no na sɛ nipa no na bia na wutrim ɛkaw ɛnyɛ me na me kan yɛ ɛyɛ Openi Jamfi versus Bedu ɛna ebiem Poku versus Poku ɛno nso ɛyɛ Supreme Court asɛm a sɛ ɛnyɛ obi bia ɔyɛ kwadwofoɔ wa wo mpɛ adwuma wa wo no unwura mu ndomo asukɔ sɛ ne mmara ne ka no na emu ba court wani ha na wo ba na no wo se court ne mmoa da bi court no ɛnya ade a court bɛ saa enti court ano asɛm a wo de bae no ɛne sɛ mmara bia ne hɔ no ma ɛbɛhyɛ maame Jane Mensah sɛ wo ma begina adaka mu na yɛtete nsɛm ne bia nkɔfɔ ka sɛ pɛpɛpɛ yonti sɛ asɛm no mu bɛda hɔ nti ka maame Jane Mensah ɔba na nkɔ begina adaka mu ana yɛdɛ abusuafo ensɛm a ɔba pa Jane Mensah so ɔka nyina ne nyina na wɔ hɔ oko abefu mfidie nso a yisi ewo ho ne nkrata ode aba court ewo ho ade kronti a maame Jane Mensah wan nyina adaka mu ne se ye nuanom NDC fo ne petition no o mentimi amfa danse a eka fom a fom pai ama court in fact ensem on be ka court nyina no e ma ye yasam a ye ka no kra no ahyemu kina ye yasam a ye ka no kra ma mo yedu enti ensem a ye ka nyina ne se omuni asem mo be ka ya ne edi kan amane se ensem no kra no nka court ni kan mongu na court said there be the beka ansɛm a ɛyɛ botaya ɛno nti ɛba ha sɛ no ne yɛ diafra enti yɛ kra ne yɛdi kan ato nkradada sɛ mo nsɛm a mo de aba court no emu ha emu nyɛ du enti abusua ɛnɛ nsɛm a ekosi yɛ no ne nyina gyina mmara so na yɛba court a sɛbi ɛnyɛ nkurobɔ ne yɛba bɛbɔ ɛna ɛnyɛ agudie ne yɛba bɛdi ɛyɛ mmara enti na yɛba ha sɛ ade bia yɛyɛ wɔ ha bia no ɛyɛ mmara enti ne yɛwɔ ha o ba fa dance bra me mana se mreyo ewo wo wasem a wo pese wo gina obi so na de ye wo wasem da bi eno enya ade a court ebepene ama sa asem no akoso abusuafo nyame ya adom a okina anase na de kye ye besa ahia na wo hwe ensam a court ebo ne tofa ne nyina na ne omo kan nyina ne se enya ade a court ebetimi ama kwan ama Madam Jane Mensah ababegina ho na central for busa asem bi na emuye me de pa sanse NDC fo bi e ka se omo withdraw omo case and withdraw omo case no kra NDC fo kasa omo dika because wunya witness no betra da kam no ka se krata ode ne nsa hya ase no e Openi rojo metonunu krata na mfumso no yeye na EC chair ne dada no wo se EC chair esake no epamo no enso na adanse aba beda di se ukonum tea na biscuit ni amfa ma wo ni nyina no ye niema ebeda di enti NDC for come for serious Openi kwasa white busa na usi nipa oba bedi dwumadi kase sei usi ufri fiaba no urafi u charger wo fie enti phone bedum ye enti nipa wo pay figures na fi no wo constituency regional level no nipa ne pese ofra wa enkomo be no betimi wadi enti ye nuanu NDC for come paba e wa asem ni mu enu enti no na omo ka tro mo nkofo se asem na be kra nka mo free court because mo am nkofo mbedi adanse kra no adanse di ombedi ye no emu eha Openi esiedu nkatia obetra da kam yamani bu nkontana ne nkontana kwakosi se na nado danko akufo adunya ohamu nchichemu aduonu ne ekirei enkota bi obu ye bia ekire saa enti esi dan enene musa ba ebeka kire se agi se mumu case ni nyentino mo de ahye mo krata mu se ehu be hia pa ma mumu case se na be mu case mbe edu agi se ma meje mensa ma be gina dakam abusuafo yenuanom NDC for any petitioners no omasem nankasa no omadwen mu omato agu enso bi eni agina mu nyame ya adom a ye beba court biem court ahye se obi amfa ne closing addresses aye ya wie no obi amfa na asem ngu krata so ne ensa emfamra nyame nhyira mo NDC case ne de atonsum na senia da me yan mesremo chairman Mark Menu aka yen chen e wa hase aka yen ho star witness on ejin mo mampani na nado danko akufuado ya mame lawyer Joy Sopoku Boatin so ha sei lawyer Faisal e wa ha lawyer Lennon enso e wa ha eye Hajia Fatimatu Abubakar eye lawyer papa ono so wa ha minister in charge of information designate ono amunsu SI eye lawyer Evans Nimakon ono in charge of elections ono nkuntabu e course ba nya no ono na di animu lawyer Kiamu a me say lawyer Sean so ejina mechi ebiem lawyer Kutampao lawyer Frank Davis lawyer Yawopon lawyer Adodapa lawyer Kwaku Asifi lawyer